Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Now we are going to discuss a case law on Medical Termination of Pregnancy Act. You may know Section 3 allows a certain category of persons to undergo the medical termination of pregnancy. Of course, between 20 and 24 weeks. Rule 3, 2021 rules have come. Rule 3 clearly says that yes, even after 24 weeks, certain categories of persons can undergo the so-called abortion or termination of pregnancy. Who are they? Rape victims, you all know. Survivor of the sexual harassment or sexual rape. Then minors, yes, even after 24 hours, they can be terminated. Then change of marital status, like becoming a widow or something at that time, it becomes difficult. The mentally ill people and malformations. If by birth, if a damage will be there or health problem will be there to the mother, definitely it will be allowed. But here, a peculiar incident has come before the Delhi High Court once again. Delhi High Court before two judges bench. This is Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad. So while rejecting the application for the abortion to Ms.x. So you can read the case as Ms.x versus the Principal Secretary, Health and Family Welfare Department, Government of India in WP Civil number 10602 by 2022 on 15/7/2022. They clearly stated that an unmarried woman who got pregnancy out of consensual sex, I can say sex, then she cannot be allowed for a termination of pregnancy. 3 points are important. Normal number 1, unmarried woman, okay. And consensual sex, I don't know what I have told you in the beginning, please remember, forgive me. Consensual sex, both of them have agreed. Partners, both of them have agreed, she got pregnancy, and after 24 weeks, I think after 20 weeks, she wanted to get terminated the pregnancy because of the social ostracism, because the partner refused to marry her. Now what to do? She has gone to the hospital, hospitals did not agree, ultimately she filed a writ petition before the court. Now actually by 18th, today, 24 weeks of gestation period is over. So now she cannot go for the so-called abortion. Before that, so many things, since it is an urgent matter, the matter came before the Chief Justice. She is 25 years old. She is unmarried. She got the pregnancy of 23 weeks, 5 days. And this happened with consent. So please remember, she wanted to get rid of the same, taking advantage of the Medical Termination of Pregnancy Rules 2021. So please remember, here the word husband. So as per the advocate, the word husband can be read as the word partner. Suppose if both of them are living like wife and husband, even though he is a partner, he can be taken as husband. This is the version of the advocate. Of course, Rule 3B, but it was not agreed to by the court because it totally rejected. For whom this Rule 3 is for the survival of rape victims or for the minors or the cadre which I have told in the beginning. So Rule 3B is against to Article 226 of the, if they allow or if they give some intermediate relief, definitely it is violation of Article 22 of the powers of the High Court given by the Constitution of India. So court cannot go against to the statute, even though it is a rule, it is a law. So no interim relief will be granted. So please remember, so Section 3 of the Medical Termination of Pregnancy Act. So please remember, the rule applies to the women who are concerned in the above category, that is rape and other things. So please remember, but now the advocate on behalf of the plaintiff, that Ms.x, he states that Rule 3 is violative of Article 14. Everybody should be equal. What is this husband? What is this partner? All these things. So she should be read as a partner. Of course, the court directed, take it to the notice of the legislature. If the legislature makes husband as partner, yes, we are ready to accept. Suppose if she is going to change the marital status like a widow, no objection. So anyway, fourth, that is 24 weeks gestation of is coming. Therefore, the Honorable Court advised, of course, it's only directory, advised the woman, why don't you go for, why don't you give birth to a child? Because why are you killing the child? There is a big queue for adoption. You need not raise the child. You need not bring up the child. So, we will advise you to go to a very good hospital, and we will keep that your whereabouts are not known. Just give birth and go away. Why do you kill the child? Of course, this is a suggestion only, but please remember, if once she gives birth, the attachment, the affinity towards the child will not leave her to discard in 99% of the cases. But whatever it is, what we have to learn is, please remember that termination of pregnancy after 24 weeks cannot be allowed at any cost. Between 20 and 24, only Rule 3B says that it is applicable on the suggestion of two medical doctors, two medical officers, to the widows, minors and things like that, but not to any other person. So, if the act is not that much of stringent, definitely so many abortions would have taken place by now. Very good judgment. Please read it and enrich your legal knowledge. Thank you very much.